Welcome to In the Name of the Law with your host, Lisa Speaker from Speaker Law Firm. Joining her today is Stephen Sinus from Sinus Dramus Law Firm, Kent Wood of Wood & Associates, PLLC, along with Mary Chartier and Takura Nyemphakusa from Chartier Nyemphakusa, PLC. Now let's discuss some remarkable stories and real cases.
Welcome to In the Name of the Law, a legal talk show about real people with real legal problems. Today's episode, we're going to talk about estate planning for families with young children, how the Michigan no-fault auto reform has affected one family, and also about a compelling criminal case. Stay tuned.
In the name of criminal defense.
I'm here today with criminal defense attorneys Mary Chartier and Takura Nyemphakusa. Now, Grand Rapids, Michigan made national headlines when a white Grand Rapids police officer shot an unarmed black man in the back of the head on April 8th, 2022. Can you tell us a little bit about who the people are that were involved with this and what happened?
Yes, Lisa, thank you. Grand Rapids Police Department Officer Christopher Scher stopped Patrick Lyoya for having an improper plate on the car that he was driving. A foot chase ensued, was followed by a very short struggle over the officer's taser, and culminated in Scher shooting Mr. Lyoya in the back of the head. Not surprisingly, Mr. Lyoya died on the spot.
So what do we know about Mr. Lyoya?
Mr. Lyoya moved to Michigan with his family in 2015. They had escaped war and civil unrest in the Democratic Republic of the Congo and lived in a refugee camp in Malawi. Mr. Lyoya attended Everett High School right here in Lansing.
So is it unusual that we know the name of the officer who shot Mr. Lyoya?
Well, in this case, it is because it took quite a while to get that name. So there were a number of protests in Grand Rapids, all of them, to my knowledge, peaceful, wanting to know the name of the officer. There were a lot of people calling on the prosecutor and the police chief to release the name of the officer involved in the shooting. And it took some time and a lot of pressure, but that name came out. What was interesting is there was a lot, the prosecutor and police wanted to protect the name of the officer, which is certainly understandable to some degree. But I know Takura knows this, and you're probably smiling. A lot of our clients are not afforded that same desire on the part of the government to protect their name. A lot of our clients have found themselves on the news, in social media, in printed media, when they haven't been charged with anything and there's just been an allegation. Either there's been a leak or the government has come right out and said that they're investigating our clients. And so there is that, counter where if you want to protect the name of the officer, that is not frequently afforded to other defendants. But here, again, ultimately, the name came out, although it took a little while.
So has Officer Scher been charged criminally for shooting Mr. Lyoya?
No, not at this point. And we won't know the answer to that for who knows. But Chris Becker is the Kent County prosecutor. He is the one who will ultimately decide whether the officer gets charged criminally or walks scot-free. Interestingly, he initially refused to recuse himself from the matter and declined the Attorney General's offer to intervene. Yet now Becker says he needs to consult with experts before he decides whether to charge Scher.
Does Prosecutor Becker have to complete his investigation before he can press charges?
No, and that's another kind of interesting aspect of this. Frequently, our clients are charged when an investigation is not fully completed. All the prosecutors will do is take a look at what has been done. Frequently, it's fairly brief and in some cases pretty cursory, and then they'll issue charges. Certainly understand why he wants to be thoughtful about this. There's a lot that will happen. If he doesn't charge the officer, we can imagine that there will certainly be outrage and protests because there's a video of a man getting shot in the back of the head. If he does charge the officer, he needs to be fairly certain that he believes that he can convict because he doesn't want to see an acquittal on the officer. So I understand the need for this thoughtful analysis. I don't know what sort of experts he's consulting with. That has not been shared, although my guess is they're individuals that he would look at to address the issue of self-defense if that's raised on the part of the officer. But the notion that an investigation has to be complete before charges are issued, that is just not accurate as it relates to many, many, many other cases that we've handled.
And
So we've
if I may add, oh, I'm sorry. I was just going to add, actually, it's not unusual for the government to pursue rebuttal witnesses after defense counsel has elicited testimony which undercuts the government's case at trial. Countless people get charged in Kent County and others throughout the country without every last bit of evidence having been recovered. And in fact, people sometimes get charged with homicide when there's no body or even a weapon.
And remember, Tukur, we had that case where the government had interviewed well over 1,000 witnesses. The investigation had lasted for years. We were just a couple of days before trial, and then the government was trying to introduce some new witnesses to add to their witness list and said, well, these people had just come forward. And so it goes not just, it happens in real time all the time.
So we've all seen the video. What more does the prosecutor have to consider?
Well, the prosecutor's got to consider what the defense will be. And if we represented the officer, I can imagine, in any defense attorney, the defense would have to be self-defense, because I don't know what else it would be. You have to justify the shooting. And so on the video, there is at least some discussion, and that's not the right word. There are at least some comments made about the taser, about letting go of the taser, not grabbing the taser, although there appears to be a witness who is saying, well, he's not grabbing it. And so there's that counter to that. So the prosecutor has to not just look at their case, but then they've got to think, okay, what will the defense be? And then how can we overcome that? And the defense would be, and we've handled self-defense cases where it essentially is it reasonable for the individual to have had a fear of imminent death or great bodily harm? And so is it reasonable for an officer to have felt that if he's grabbing at the taser and he gets the taser away, and let's say he tases the officer, would there be great bodily harm or imminent death from that? Possibly, and again, I don't represent him and we don't represent him, but the prosecutor has to think about what will that defense be and how can we overcome that? And so they also have to consider, what experts will we bring in to try and say that's not reasonable for this officer to have had that fear?
So is this the first time that Prosecutor Becker has had to make a decision about whether to criminally prosecute an officer?
No, Lisa. Becker has reviewed 5 police shootings since 2020, and he has ruled on at least 11 police shootings since he took office in 2017. Only 1 has resulted in charges against an officer.
So how does a stop for a minor traffic offense result in Mr. Lyotta's death?
That's what everybody, I think, should be asking themselves. It's a tremendous tragedy here, no matter what the result is in terms of charges or a conviction. But I think we've really got to look at, as a community, how does this happen? How does a stop for an improper plate result in a man being killed on a lawn? And then what is the policy and practice of the police? Should this officer have pursued this young man? Even if people are going to say, and a lot of people do, well, he shouldn't have tried to run from the police. Okay, well, then is the result of that the police get to shoot you in the back of the head? And so should that pursuit have even happened? And then that might not be an issue of what the officer chose to do. That might be an issue of what are the practices and procedures and policies of the Grand Rapids Police Department, and then broader, of all the police in our state and in states everywhere. Should we be pulling people over for these minor traffic offenses, and then if someone, for whatever reason, they're frightened of the police? He came from a country where, government is certainly not trustworthy. If he has that fear and runs from the police, should the police officer have followed him? He had the car right there. Or would a better practice have been, again, you impound the vehicle, then ultimately you're going to see this person. So there's a lot to look at from the community standpoint about how officers are policing our communities, how they are treating our citizens, how we can minimize this. And hopefully this young man's death will result in some positive changes in the community. And as you know, Lisa, we explore these issues, exonerations, and far more on our podcast called Constitutional Defenders, which is available on every single podcast. And we're definitely going to be staying tuned to what happens in Grand Rapids on this.
Thank you.
In the Name of Criminal Defense is brought to you by Chartier Nyamfukusa PLC. In the Name of Family Law.
Hello and welcome back, Kent. We have Kent Wood today. He is a owner and lead attorney of Wood & Associates. They have offices in Mid-Michigan and West Michigan. And today we're going to talk about estate planning for parents with young children. Kent, we can't wait to hear what you have to say.
Oh, well, I hope I can help today. So when it comes to estate planning with children, the first thing is you need a will or a trust, something that says, this is who I want to care for my children if something should happen to me, my significant other. And the court will give priority to whoever you name in what's called a testamentary gift, which is just a fancy way of saying you have a will or trust.
And so is it you said they have priority. Is there something that the court will look at to make sure that person that has been selected is appropriate?
Oh, the court will always make sure whoever the either the appointed or suggested person is appropriate and in the best interest of the children. That's always kind of a gathering when it comes to custody and guardian matters. When it comes to probate, they'll look and see if your history. Are you in the central registry? It's not likely to happen. If your family.
And just to clarify, the central registry for abuse and neglect.
For abuse and neglect,
okay.
Excuse me. Yeah. Or there's some sort of other sexual offense or other background criminal history that's going to cause concern. Other things that may cause concern is maybe your financial situation may cause the court some concern in terms of being able to care for the children, or there may be money in that estate for the child that could be tempted to use by the guardian.
Well, let's talk about that. How do we protect the children financially with our estate plan?
Well, anything that passes through probate, so if you have money that's going to probate, like in a bank account, if your house has to be sold, that's going to go to probate. Even if you have life insurance that you name your other spouse or your spouse or significant other as the primary beneficiary, if you both have passed away, both parents have passed away, and the money has to go through probate, what will happen is that money will go into a restricted account, and they'll appoint a property guardian to watch over that. When I say they, the court will appoint
a restricted account at the court?
Yes, the court. With the court.
Okay.
So the court's going to appoint somebody basically to say, hey, this money has to be used for your children. It's a good thing, so that it's used wisely. I've had situations where that did not happen, and we had to undo some of that. But it's also very restrictive. They set up a monthly payment. Then if you need things for band or soccer or a school, trip to Europe or something because the class is going, it's harder to get that funds out. The other difficult thing that and troublesome thing is that when the child turns 18 in that situation, they just get all the money. And I've got good kids, but I don't think they're going to be ready to handle a large sum of money when they turn 18.
So I think you have created an option to help parents with this situation. Can you tell us about that?
Yes. So the one way to avoid probate is to use a trust. But most young families who have young children don't have lots of money to pull to trust. The trust can range anywhere from $3,000 to $5,000 depending on where you go. That's a little pricey. And so I was challenged by a financial planner, a mentor of mine. He said, is there any way we can solve this problem with it all kind of going to the child at 18? Well, trust would solve that problem because the stuff wouldn't go through probate. So I've created a smaller version of a trust that only handles financial assets. It doesn't handle real property, it doesn't handle businesses, it handles just finances. So if it can be liquidated and put into there, that's fine, but it won't sell a house. It doesn't have any of that authority. So all the money can funnel into this thing, and then you can appoint your guardian for your children there. You can also appoint a trustee. And then you have what I call the two parents if you both pass away. You have somebody handling the money and you have somebody watching over the kids. And they have to work together to do what's best for the kids, kind of replacing the parent roles, because you do that naturally in a family situation. But I've created, it's 15 questions. You only need to answer 10 to 15 of them depending on what the situation circumstances are. And it's no frills. So I created so it ends up being about $600. I even allow people to pay $50 a month because, again, it's geared towards young families whose main assets are maybe a house, but they have 2 children and they have some life insurance or some money in the bank. And it's just there to help them. And then there's a trust. They can avoid probate, and then they can delay that distribution out, usually until about 35, 40. I usually have them set up in steps and stages when they can have it, so that they can go to school, buy a house, get married, those kinds of things.
So yeah, let's talk a little bit about what happens at 18 and how, like, I'm assuming there's some variability based on your client about how long the trust will last, right?
Right. So when the child turns 18, nothing happens depending on what the trust says. All the funds are in the trust, and then it'll have direction about, do you want to use it for schooling? Do you want to use it for weddings? Do you want to use it for buying a new house, starting a business? These are some of the quick questions to ask. And then one of the questions I ask is, when do you want them to be able to get the rest of the money?
The end date, right?
So give them we always kind of build in this thing where, okay, you get some at 25, and if you made bad choices, it's okay. You're going to get some more at 30 and 35. And that's usually the numbers we kind of fall into when I'm advising. They could be longer,
Right.
but there's can't be too long for trust rules.
Okay.
So,
and what about who would be the trustee in this situation?
You would pick the person.
Okay.
Obviously, you'd pick somebody that would work well with your guardian, somebody who's financially stable, so they're going to be controlling the money, so they don't want to have any temptation. Right? A lot of good intentions can spend a lot of money, and so you'd pick someone who's that. And then again, somebody who works well with wherever your children are staying. One of the other advantages I tell people about picking who gets to raise your children is, and having it in a will or trust, is you get to pick them. Otherwise, family sometimes gets priority under the rules, and you might love your family, but you want your kids raised in Michigan, but your family lives in California. You want them raised in a certain faith, but they are in a different faith. So it's a lot of protections on there in terms of what's kind of important in instilling your values still within your children even after you've passed away.
So you mentioned financial assets that would go into the trust. I'm guessing that one of the easiest ways to have some money in that trust to help support the children when you're gone is to have a life insurance policy?
Yep. So life insurance, we always advise clients to name their significant other as the primary, but then name this trust we create as the contingent beneficiary. So if something should happen, it will go straight here. The trustee can get that money quickly. It's not sitting in a restricted account within the probate system. Because if you don't have anybody named, it's going to your estate, which means it's going to probate.
Right.
And if it's going to the minor child.
And what if something happened to the person you named as trustee, if they're no longer available or they've passed away? Does the court then have to decide, or how does
the court can decide. We always have at least one backup listed in the trust itself. And many backups as you want. That's one of the questions. But we always recommend at least one. But there is a provision for the court to decide, or the remaining surviving beneficiaries can decide to some extent depending on their age as well.
So this actually brings me to, I think, an important point that it's probably a good idea, if you're going to do this mini children's trust, I think you called it, right? Yes. Let's say we do it today when the kids are not even in school. You probably are encouraging your clients to come back every couple of years to update it, or what kind of updates are necessary?
New updates are necessary when there's more children born. We have it drafted, so anticipating more children born when they're young families. But it's always better to have specific names. Purchasing new homes, inheriting, coming into more money on your own some way. If you have more bank accounts than now you're using, the bank accounts can have beneficiaries as well, just like life insurance.
Great.
So anywhere you can put a beneficiary, we tell people to do so.
Well, thank you, Ken. We really appreciate it.
Oh, thank you.
In the Name of Family Law is brought to you by Wood & Associates, PLLC. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Personal Injury Law.
I'm here today with Steve Sinus, a partner at the Sinus Dramus Law Firm, and two guests, John and Andrea Kenzer. Steve, tell us why you brought these special guests with you today.
I'm honored to have them here. We have Andrea Kenzer.
Yep, happy to be here.
And John. And they have been clients of mine, and they've actually been on the show before. They came on a couple of years ago to talk about how important the Michigan no-fault insurance system has been for them, how much it's aided John's care and recovery. And so that was great to have them on back then. Since then, we've had reforms passed to our no-fault insurance law. Those were passed in 2019, and some really restrictive rules under those new laws went into effect this last July. And our firm is trying our best to represent people in this kind of chaotic situation where people are trying to understand what their rights are. And one thing that's really unfortunate about the reforms is that not only are insurance companies trying to apply them to people going forward who are injured after the laws were implemented, they are now trying to go back and apply them to people who are injured prior to the implementation of the reforms. These are people who bought insurance policies based on the old law, based on the old standards regarding how much they get paid, how much their medical providers get paid. And now the insurance companies are trying to apply them to people who had those policies. And that's what's happening to the Kensers. So
I also want to add people who have negotiated contracts with the insurance companies after they've been injured, right? It's not just that they were relying on the old law, they also actually had agreements.
that's right. And a whole customary way they got paid. And like Andrea, she's adjusted her entire life to be the sole care provider for John. She provides great care. And Andrea, how have things changed for you since the implementation of the reforms?
Well, almost immediately, they stopped paying like the normal pay. It's like 56 hours a week. That's it. And it's obvious John still needs the 24/7. His doctor says he needs it. We have a script for it, but that's it. And the therapists aren't getting paid as much, but I don't even get equipment that I need on time. Everything has changed. Everything.
And let me explain to the viewers, the 56 hours that she's referencing, under the new law, it says that family members and friends or anybody who had a prior business or social relationship with the person, anybody who provides care who falls in that category, the payment is limited to 56 hours a week. So in the Kenzer situation, their insurance company was paying them 24 hours a day, 7 days a week. And now this law is passed and they say, okay, we only have to pay you 56 hours.
Yeah.
Right?
Yes.
Even though she's still providing full-time,
Yes.
24-hour-a-day care.
Right.
still
And even
doing
though
that.
she's, they're still claiming benefits under the policy that was sold under the old rules.
Can we go back just for a second? And Andrea, can you tell us a little bit about the accident that brought us here in the first place?
Yes. Back in 2002, John was coming home from playing hockey and he hit black ice. And his car spun out of control, hit a tree, and he was in a coma for 6 months after that. We were told he probably wouldn't get better, so stick him in a nursing home and take a vacation, they said. Good advice. But I didn't like that. So I got guardianship of him and brought him home. And that's where we started actual therapy.
So this is back probably 2003 by the time the
Yeah,
actual
he came
therapy
home
started?
in July of 2003 on tube feeding, on a vent, everything. But I wanted him home.
And can you tell us about the improvements he made over the course of the many years until the 2019 law change?
Oh my goodness. Well, first of all, he's walking, with a cane or with a walker, but that's still walking. His speech is still ongoing, but he can actually be understood now if he goes really slowly. I mean, it has made huge gains in his life. He'd be probably dead by now, but if not, in a nursing home, I'm sure.
John, can you express yourself with the iPad?
Hi, good to be here.
Thank you, John.
So, the segment we did a couple years ago with them was focusing on how no fault has really benefited John and really given him a quality of life because it was there to pay for his providers at a rate that they could, sustain financially.
Yes.
And for you were able to take the payments and have enough money to live off of while you're his main care provider.
Right. And that's what the bulk of it was. I mean, he had to be taken care of. He couldn't do anything by himself. I had to supervise everything. And it was a long, horrible road. But I'll tell you what, he wouldn't be here today without no fault.
But now the system you're encountering is completely different in many respects?
Completely different because, first of all, they stop paying you. And they say, we'll give you 56 hours a week. And I did say, come to my house, please, and see how he doesn't sleep at night, see how things are going. They said, we don't have time, they said. So they just cut everyone off to 56 hours a week. And that's what we're living on.
And with your providers, they're obviously more stressed than before?
The providers, I have to pay for all of my own things before I go in because they're not assured of a payment from the auto insurance. So we have to pay ahead of time when we go in. And I've also been advised to change doctors, but I don't want to. They've known him all this time. They're great doctors. I'm not changing. So I'm paying for it myself.
So we're doing this segment here to bring awareness about how these reforms, these new rules and regulations that apply in the no-fault system are really having an effect on people's ability to access care.
And you can access it if you want to pay for it yourself. And that's why we have insurance, is because it's expensive, it's long and tedious.
I want to point out, you to pay for it yourself, but you don't have a job because you're
Correct.
taking care of your son full time. Like, it's not like you can make money doing something else.
No, you can't, unless I take him to work. But how do you know? No one would let you bring your son to work with you while you're doing your job. That's not going to happen.
Yeah, just appreciate the absurdity of it. Our legislature passed a law that took away the payments to Andrea Kenzer that she was relying on to be this great care provider for her son.
And I'm still doing it, but it causes you a lot of stress, a lot of stress.
What our firm is hoping is that eventually the courts will recognize that, at least for people like the Kenzers who did buy these policies based on premiums that were calibrated around the old rules, that the courts will recognize that these new rules can't apply to those people because they had their contractually bargained for rights and that they need to stay intact. Unfortunately, that whole process is taking quite some time to move through the appellate courts, and people like the Kenzers are hanging in the balance.
Mm-hmm.
And for me, it's just really disheartening to see a system that served so many people and do so much good now turn into a system where the most catastrophically injured have to be beggars, have to basically play by the insurance company's rules every step of the way to get any payment.
And that's what it's boiled down to, because they really have you in a corner, because I can't go to work. I cannot do it.
Go ahead, John.
Not a beggar.
Not a beggar. Well, when they have a law that says that they don't have to pay you more than 56 hours a
Your
week
mother
unless
might be
they
a
want
beggar
to.
then pretty quick.
Well, and what about the care providers, the medical providers who aren't able to stay in business with the new constraints that have been placed on them by the
Correct,
legislation?
because I'm about to lose my case manager because they haven't been paid either for any of their services. I think they were told they don't really need them.
Well,
I need them.
Let me make this point before we wrap up here. Unfortunately, this reality has been brought to the attention of our legislators, but they have refused to fix the problem. Several amendments have been proposed, and they're refusing to fix it while people like the Kenzers are suffering.
And we've been waiting for the court case for a very long time to be decided, and it's still sitting there.
Why are we here?
Yeah.
So is there any remedy? I mean, what do we do?
John and Andrea, thank you so much for coming in again. We
Thank you for
really
having
appreciate
us.
it.
Thank you.
Thank you, Steve.
In the Name of Personal Injury Law is brought to you by the Sinus Dramus Law Firm.
Thank you for joining us today with In the Name of the Law. We look forward to seeing you next week.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.